Maybe online, we'll see. Yeah. We'll go through them again. Jonna Drake. We'll see. That's not quite done yet, so that's all right. Gary.
Here.
Tara. Here. Lori. Here. Me. Jordan.
Here.
Jordan's online. Mike Scholl. Jessica Schneider.
Here.
Ron Stoddart.
Here.
Patricia Swagger. Here. Merlin Thompson.
Here.
Shane Vick.
Here.
Natalie Walsh. Here. All right. So we'll give them a minute and we'll double check. Right? Yep. Cool. So, anything that needs to be changed from last week's minutes? Commissioner Walsh.
I had one change because it was substantively incorrect. It's on, do you want the page?
Yes.
It is on page 7 of 15 of this packet. Areas of focus for the presentation and invitations, the second paragraph down. I wrote out the correction. So can I just read that and then I'll email it to someone? Okay. So it starts, Commissioner Walsh, that paragraph. Commissioner Walsh stated her desire to have, this is my correction. Commissioner Walsh stated her desire to have someone at the management level of the city discuss the complaint filed, meaning the complaint in the litigation, and the related press releases with the CTC during an upcoming CTC meeting. Walsh stated that there's confusion among community members about whose activities gave rise to the Garner litigation, which has led to distrust of the LPD. This is another correction. Walsh referred to the complaint allegations that specify the city's failure to train and failure to supervise as the basis of the city's liability. And then I left the rest of the paragraph the same.
Yeah, if you could email that, then we will adjust it.
Okay, to you and Jeffrey?
Jordan and Jeffrey.
Jordan and Jeffrey, okay. Thank you.
Yeah.
So do I have to make a motion or someone does that?
Yeah, I move to amend the minutes to change them to what Commissioner Walsh just read.
I'll second. This is Commissioner Schneider.
Good. All in favor?
I also have a,
Let's do that
Okay.
one first.
Okay,
So everybody in favor of Commissioner Walsh's changes? All right, motion passes. Okay, and then Commissioner Black?
I just wanted to, I didn't see in the minutes reflected, the city attorney commented and explained to us that recommendations to the city manager, that then at the next, we make recommendations to the city manager, then at the next meeting, city manager makes a determination based on which one of our recommendations he can fulfill and which ones he cannot. I did not see that reflected in the minutes, and I would like that to be in there. And I would also like to see on page 8 and the third to last paragraph, third to last sentence, Adam stated that a general request to key city representatives will allow him to ensure that appropriate staff are included. That's not what he stated verbatim. He said, he interrupted Chair Pryor and said, "You're too deep, commissioners. You need to ask me to bring the appropriate staff to have a walkthrough." Stop, interrupted Chair Pryor again, "and I will tell you who that is. And then I will consider this." And I really did want that reflected in our minutes, that exchange.
Okay, so that was kind of a two-parter. So the first part is everybody, I moved Does anybody want to make a motion? There we go, to approve the spirit of that change? And then we can adjust it in an email. Is that,
I'll make a motion.
Would it be possible to have that typed out
yes.
in front of us before we approve it or approve the minutes with these changes? And
Yeah, that's, so let's,
I know it's probably partly the math, but I can hear about 2/3 of what people are saying.
okay.
Absolutely.
So we will need them,
I didn't do.
that's okay, we will need them typed and sent in, so if that's acceptable to you, and then we can read it and then vote on it next time. Is that all?
That would be great.
And also, sorry, this is Commissioner Schneider. We have those video recordings, so that should hopefully be easy to type out.
Is that good?
And also just a reminder to try to use your microphones, so you all can hear one another as well as capturing the notes.
Okie dokie. So we'll move that to next time. Commissioner Black will write up that in an email and send it to the CTC, and then we will have it and can look at it in front of us next time to approve it. Good? Does anybody have, oh, sorry. Yes. Yes.
I don't think we ever approved the meeting minutes prior, which are in here adding the new things. We still need to make a motion to approve the November meeting minutes, the last meeting in November.
We never, okay. So I move to accept the minutes for meeting 3 as adjusted and currently written.
Sorry, this is Commissioner Schneider.
Or
We-
from week 3, we did not approve last week.
We did not, and it was because well, one of the reasons was because I asked for my motion that didn't get a chance for a vote to be passed, to be reflected in the minutes. And I have not seen those new minutes with that reflected. If I'm missing something, please let me know. Otherwise, that's something that still needs to be done, I believe.
Those are in the meeting, this from last meeting. The call to order, and it says Commissioner Schneider requested Commissioner Thompson. Those two things when we were tabled on. Those are correct.
I'm sorry, I'm having a hard time hearing.
Is that better?
Yes, thank you.
It just says that, I don't know if you have, do you have the meeting minutes in front of you?
I just read them. I don't have them in front of me right now.
They're in there, and so the call to order and the meeting minutes for this, from last week, reflect the changes that I believe you requested. So before we get too far tabling meeting minutes, right, we should probably go back and approve those. Right, Commissioner Schneider requested the motion she made in the previous meeting regarding remote participation be included in the minutes. And then Commissioner Thompson requested his attendance record be changed that reflects that he was actually here, right?
Okay. So the original minutes aren't going to be changed? I guess that's my question.
That's right. So those motions from last week's minutes are in that, requesting for those changes, and the minutes have been updated. And I guess I need to double check that they were part of the packet. So I'm sorry, I thought that they were, but that piece has been put in. Looks like we need to make sure to get that to you all. So sorry that you haven't, and we'll distribute that. And you can look at what the addition is to make sure that we captured it correctly.
I appreciate that, because I did check the minutes recently, a few minutes ago, from like when we get the email where it's like, here's the links to the minutes and agendas, and those minutes had not been updated. So anyway, appreciate that.
We accept them. We have not accepted them. So table again. So let's table this again. We'll share them next meeting and accept next meeting for week 3. And then week 4 also, we'll make those adjustments and then accept them next week as well. So does anybody have anything they would like to add or change to the agenda? Is there anything crazy important? Does it all look good?
To tonight's agenda? Sorry, I'm talking so much. This is Commissioner Schneider. Is that what you're asking?
Yes.
I want to just bring up the group email and make sure that we address the group email situation, and that everyone knows how to get on it, if we know who is on it, etc.
Cool. Guess we update from city. Let's see.
Does that require a motion?
No. No.
Real quick, this is Commissioner Pryor. I do believe that that should be a part of the update that we're given in the, sorry, I'm having to look at the agenda here. Brief update from the city about accessibility and public comments. I think it should fall under that. But correct me if I'm wrong.
Oh, I think that's it. We can go ahead and move on to that. City Manager Adams, could you help us out there with that, please?
Thank you, Commissioner. Appreciate that. So I think the question is, one of the motions that was made last time was to record the meetings and have them available to the public. And so tonight we are recording the meeting also, and we will be, the recording when it's completed, well, we will be uploading it to YouTube, and we will be sending back to the CTC so it can go out to all of you, the link, so that you know where it is. So that was a request from last time, and that was the accessibility part of the meeting, getting that on videoed and everything. So that's in progress tonight, right now. So the second part, I think, was a discussion that you all had started, which was to talk about how you wanted to handle something that's on the minutes, but it's really not happening yet. And that was if people wanted to email in a comment that they wanted read. I think that's what this is. And so.
Yeah, that's what it is. You know, there was an email that.
Clarify, let me sure.
Sorry.
So the council has that feature in their meetings. And so the kind of question was, is that something that the board wants to do here, this commission wants? And so we've talked to Jeffrey a little bit about how we can make this work. So I think we have a way to make it work. And the way that would happen is you would establish a cutoff of, say, 5 o'clock tonight. Anybody that has an email they want read to the commission as a whole, under public comment, would have till 5 o'clock, say, to do that. Then they would email it to the CTC web page. We had worked with Jeffrey, and we think Patrick could then get all those emails, because we're worried about production now. So he would get all those emails, and which ones came in, he would then, when you called on is there any minutes or any comments from the public to be read into the record, he would be able to say, yes, I have 3. And he would read those off.
And I think there's only one addition to that, which is because people will be using this email to write you generally. People can write you anytime. They can send you any questions they have, any requests, those kind of things. But if they want this to be distinguished as a formal public comment, that the subject heading would include for formal public comment.
Right.
And then the whatever else they put into their subject heading.
And we'll post, I mean, we didn't do it tonight because we wanted to make sure you were okay with it. You vote on it, that you want it this way. But then we would have that on the subject line as to be read as a public comment. In the city, we actually have a separate website for it. We didn't want to make it that complicated. So we think this way, if you just have it the subject line, people can write that in, and we'll have it in the instructions here on the first page so people can see how to do it.
So then we would I motion that we accept Mr. Adams' or not request. Yeah, what he said.
Before
So
we
we would
sorry.
scratch that.
If you want,
We would allow the CTC email address to be used for public comment with the instructions that people write, if it's going to be read in the group, that they would write that in the heading.
on the subject.
Yeah, subject
On the
line.
subject. Yeah,
Sorry, guys.
we can do it.
I think this is Commissioner Schneider. I think there's another part of that, is that there was a group email for the CTC that we were supposed to opt into. I just want to know if everyone's opted into that, and if it's working, if it's not, when that will be working.
Madam Chair, could I suggest that we handle one thing at a time?
Yeah, so Commissioner Schneider, let's hang on for just a second. So do we have a second for that motion, for my motion? Second, all in favor? Motion
Got it.
passes.
Okay, thank you.
Okay, so then,
Then, let's get this one.
You were asking if it's functioning?
Yeah, I would like to know if all the commissioners have opted in, what they need to do to opt in. I know there was an email that's in our packet from a community member who sent an email and it wasn't received by all of us. So I just want to know, is this a functional tool that we should be sharing with residents? Like, this is how you can reach all of us at once for general thoughts, or not?
I'll just add that after that email was submitted to us, as you all saw, I went around and kind of prompted people to see if they wanted to sign up again. I think most commissioners signed up to receive those. So it seems to me that I'm not sure we've had a test since others, because the people that were on the list the first time, I think, got it, although there was a couple that went to their spam and things like that. So I guess to me that was, there was a little bit of confusion about when this email came in, because the writer was wanted it read at the last meeting, but I got it after the last meeting. So that's the only question I have. But I would say that I now have a list of people that wanted to sign up. They're signed up, and I guess I'm wondering if there's any information from the city on, is that when the letter came in on Saturday, which is when most of us received it that were signed up, and if so, it's working. If not, maybe we do a test to see if it's working. But I guess the only information I have is that there's now several of you, most of you, have signed up to receive those. And I would also say that I think you all received, at least I forwarded that email sort of manually. So I think folks have seen that. Okay.
So then, can we run a test this week? Would that work? Like run an email test? Would that make sense, Commissioner Schneider?
Yeah, I think so. I could run it right now. I just want to make sure when our residents are invited to communicate with the Trust Commission that they know that we are receiving their messages. Otherwise, I feel it's disingenuous and is going to erode trust, which is the opposite of our goal.
And I have a follow-up question.
I had not responded to that, and I did want to be included in that. So if you could put me down and we'll talk,
Noted.
So when we get an email like that through that email, we as commissioners can respond individually to that individual, or is that a dangerous slope to be on?
I pass this to you, Mr. Garcia.
Sure. The answer really is that it should be going back to the commission. Number one, you don't want to provide your personal email address. That's one of the things we're trying to do to protect your own privacy. But secondly, you operate as a unit. So really you want to hear if there's any comments, you want everybody to share in those comments so that if you have a response, it's a response by one unified body.
So then we read them here and we all have a chance to chime in, right?
Yeah, so I had a question and then a comment. My question is, we're talking just about one email that we were sent on Saturday, December 11th. Okay, I wanted to make sure because I did get that. It was in my spam. It's all good now, I hope. And then my second comment regarding replying, I agree we don't want to reply as individuals, but it's nice to let the person who's writing know that somebody saw it, especially like in this case, we got it on the 11th. We don't meet till the 20th, so we don't hear the person, for like a week, so they don't know if it's in a big black hole or whatever. So I'm wondering if there is either an automatic reply that can say something like, yep, we got it, it'll be considered at the next meeting, or if we can authorize maybe Jeffrey or the chair to just respond and say, thanks for writing, or something like that. We'll read your comment at the next meeting. That's just a question or suggestion.
Thank you. City Attorney Garcia, can you clarify what you just said about I think we are not supposed to have a group discussion on email from an opens meetings perspective. And so I just want you to clarify what you were describing in light of that, because if we can all communicate via email, we were kind of doing that in the beginning and we were admonished. So I think people are being real careful about that.
What I would say is that when it is.
You're not on.
Could you please turn your microphone on?
There.
3 or more members of the commission together, that's really where there's an issue. If you're speaking directly to the citizen, that is really not an issue other than the fact that you're not speaking as a unified body. You know, you might have a response that might be very different than what the commission members do.
If I can clarify, that wasn't what I was asking. An email from a member of the public would be distributed to the group. We're not responding individually to that person, and we act as a body. So we are also, I think what was left out of your statement is, we are not supposed to then, during that week, have a email meeting about that public comment. I think we're supposed to wait until we're in a meeting that's been duly noticed up. If not, I mean, I would love to be able to communicate via email with everyone. So,
Thank you very much. You're absolutely right. There shouldn't be any discussion among members based on that is unsatisfactory.
yeah.
Really quick, guys, can we please identify ourselves for the note taker? So every time you speak, please just let them know who you are. So, Commissioner Mayor.
Sorry, Patrick.
All right, so can we have a motion to have the automatic reply for an email? Would somebody like to make that?
Well, it was my suggestion, so I'll make a motion that we have some sort of automatic, thank you for your, is the city able to do that?
Commissioner, could you allow us the flexibility to develop a system to acknowledge receipt of the email? I'm not sure if we can do an auto from this website. We'll have to do the work, but I think what you're saying is somebody needs to say, thank you for the email.
Yep. So I'd like to make a motion that receipt of an email from a member of the public is acknowledged by some sort of return email.
Can we vote? All in favor? Motion passes. All right. We have public comment. All right, we have public comment next. We do have that one email. Jordan, do you want to read that? Do you want me to read that?
Real quick, before we get to public comment, we do need to vote on the potentially removing the time limit for our meetings.
Got it. Real quick. Okay. So last week or 2 weeks ago, our last meeting, it was brought up to us that we are the only commission that currently has a time limit, and we chose to impose that ourselves, and so we can take that away so that we don't have to end the meeting exactly at 8:30. Otherwise, when we go over 8:30, we end up kind of in the trouble zone of our own rules, right? So let's go ahead and vote on getting rid of that. So I move that we eliminate the end time and we end when we end, with the expectation that we're done around 8:30.
I second.
All right, all in favor? All opposed? Oh, do it again. So 1, 2, 3, 4. Right, were you in favor?
Oh, I was in favor. Yeah, I had my
Okay,
hand up.
so motion passes. Actually, just kidding. City Attorney, does that one need to be a 2/3 vote?
No.
Excuse me, Madam Chair. What was the vote?
4. So it's 2/3.
Some doesn't.
Madam Chair, the rule is that it would be, for this particular meeting, it would require a 2/3 vote. Going forward, it would require a majority vote. So usually you do it in 2 pieces. You say tonight, would you like to suspend the rules and allow us to go as long as we need? And you have a vote. And you say 2/3 for tonight, because it's kind of for the moment. going forward, saying, starting next meeting, do we want to do it, but it won't take the majority.
Okay, so that's a two-parter then. So for tonight, would we like to extend the time limit? Take as long as we need. Could I please have all in favor raise their hand? Yeah, 1, 2, 3, 4, 5, 6, 7, 8, 9. Okay, all opposed? 1, 2, 3, 4. That's 2/3.
Did you get the votes online?
Yes,
Okay.
yes. Thirds? That's Matt. So that motion fails. Would we like to then, second part of the motion, would we like to do this going forward? I'm guessing it's the same votes, but
I'm sorry.
like get rid of our end time and go as long as needed.
May I say something, please?
Commissioner Barrett.
Thank you. Commissioner Barrett, I just wanted to have a little bit of a discussion about why this is needed. Last week, City Manager Adams had to jump out of his seat and tell Commissioner Pryor that he had to end the meeting right now because we have this rule in place. If we don't have this rule in place, then we have more of an opportunity to extend as we need to, if we need to. I think it's everyone's intention to make this as brief as possible and get out on time. But that would actually, again, we are the only commission who has that limitation, and we can be in violation of our own rules if we don't change that rule.
This is Commissioner Schneider. May I speak?
Yes, go ahead.
Thank you, Catherine. I agree with what you're saying. I also think that saying like, should the meetings go on until we're done is a long thing. I do appreciate the idea that we can say, we want to extend for 20 more minutes. Right. And we vote in increments as that goes. So I guess maybe that would be more particular. I'm not sure if that suits what you were saying too, Catherine. I'm not trying to.
No, I agree with you. And I wonder if we need some clarification from City Manager Adams.
Great.
Okay, Commissioner Black is next. No, just kidding. Commissioner Scholl.
I, as somebody who kind of voted against it, perhaps out of slight frustration, I wanted to at least kind of address my concern. And, one is it's actually just after 7 o'clock. We're now where we should have the CIRSA attorney who's come from Denver speaking. I think before we start kind of extending time, I think we have to have some culture or agree to some norms about kind of meeting efficiency. And I don't, I like if there's issues that come up regarding the minutes and different things that we could do quickly, that we kind of address that either through direct kind of email with the chair or with Jeffrey beforehand or something, because I feel like, we spend a lot of time not doing the substantive things that we've been charged with doing. And so I think my vote in opposition was a little bit out of protest and frustration. So I'll leave it at that.
May I speak, please?
No.
Chairwoman?
There's got to be a cap on it, because some of these discussions in the future are going to go and go. So, if you want to extend it to like 9 p.m. or whatever, I just think there needs to be an end cap, because this is going to be a hot topic.
Commissioner Pryor.
Thank you. So I completely agree with, we don't want it to go for too long. I think a cap may not be a bad idea, but definitely extending it is something that we need to look at, because as we've seen, we can't get what we need to get done in 90 minutes. And even with today, like Mr. Scholl had mentioned, we are already behind, and this meeting was originally intended to be set up to where, if we did pass this, we were going to have enough time to do everything. And as it stands, we are going to have to extend the meeting regardless. So thank you.
So then, do we want to amend the motion? All right, Ron.
Madam Chair, I think it might be more productive if you and Jordan and Jeffrey talked about what we want to change this to, and maybe some things that will streamline what we're doing. Like if there's going to be corrections to the minutes, they should be emailed to Jeffrey ahead of time so that we can all see that and move quickly on some of the things that are just not monumental. And if you could put that together for the next meeting, and perhaps with maybe a longer, maybe 2 hours instead of an hour and a half, but not unlimited. If it's unlimited, I think that we know what'll happen.
Okay, so let's table this for now. Work on our procedures, and then we'll get back to it next week. Yeah, so let's go ahead and let's go with the public comment. Jordan, did you want to read the email, or do you want me to read it?
If you could read it, please. I'm a little stuffy right now. Thank you.
So we did receive one email this week. It came in on the 11th. Okay, so first of all, I would like to thank this committee for its time, for your commitment to this city and doing what you can to make this a better place. I respect greatly the mission and your efforts to confront the deep, systematic problem we have in Loveland leadership. I am pleased this body has decided to focus on police accountability as its first mission, but for the tragic events over the last few years, there would be no trust commission. I believe you have chosen wisely to address the police department. After watching the last meeting, I was struck by a comment made that there was some social media outrage that a committee member may be a police officer, which he isn't, and that would be a conflict of interest. I agree it would in fact be, but let's address the elephant in the room. The one person who had the power to proactively act from the very beginning. Our city manager is the one who could have acted when a Brady listed officer was kept on payroll or an elderly man was abused by Sergeant Metzler. He could have acted when a witness was beaten or a man was roughly arrested during a mental health crisis, but Mr. Adams did nothing even when the now infamous Gardner video became public. A $3 million judgment, followed by a dead dog and sadly a dead teenager. Mr. Adams sits silent without one proactive measure. He sits waiting for outside agencies to tell him what to do. What exactly is your role, Mr. Adams? In my humble opinion, it's a, acronym. Your very presence at this committee to address trust taints the mission because you, in fact, are part of the problem. You helped create the distrust. But here you are pretending to have clean hands. This is exactly why we can't trust the department, city leadership, or our biased council. There is no finer example than Mr. Adams sitting there. What Chief Ticer has been able to accomplish in just a few years, since 2017, is a lifetime of scandal in any department. It's disgraceful. He should be removed from his duty effective 2 years ago. Mr. Adams, are the city manager, you are a policymaker, you are the oversight, and you have failed in your duties. You want trust, earn it. Okay, so that was from Deborah Zeris, short. Is there any other public comment?
Good evening, everybody. I was here, I think, just previously, I guess it was 2 weeks ago. It was made by a commissioner. This city already has an oversight board of the police department. It's starting to hear that because no such thing exists, no such thing has ever existed. It's the last thing the city. It's just a simple organization of citizens that have communication with the police department.
I'm so sorry. This is Commissioner Schneider. Bill, we can't hear you.
So, I want to point out that successful lawsuit.
Hello.
The member cash of PCOB is the one that put forth the ordinance for you guys to be created. And that was done as a the political behavior to get elected, which he lost. So just bear in mind when you get to it, and here becomes the actual behavior. That's my comment.
I'm so sorry. This is Commissioner Schneider. Bill Jensen, we could not hear, those of us that are online could not hear anything that you said. The microphone was garbled. I don't know if I need to make a motion to ask you to speak again if you're willing to, but unfortunately I was not able to hear what you said, and I would like to. Can anyone hear me?
I agree with that. I'd like to hear what he had to say too, and there was just no way to understand what he was saying.
I have another mic. If you want to give your comment, if you can give your comment again, we'll pull another mic down there if that mic's problematic.
Thank you so much.
Thank you.
Is that better?
Yes, so far. Thank you.
Thank you.
Okay. So that was spontaneous. I don't duplicate that, but my point was that the police
Bill, it's still not working. I'm so sorry.
And the police department, any oversight. See, the reason why I'm speaking tonight is because 2 weeks ago, it was brought forth by a commissioner that oversight. This commission might be stepping on their toes, or there might be some kind of like conflicting. That because the reason why you guys were set up, one reason you guys were set up is because there is no oversight in this city. Not that you guys have any oversight, you guys don't. You guys are more about advice to city council about somehow having a community of trust, which is part of your name. Wanted to slow down and point out that you guys should know that the PCAB is not that there is not an oversight board at all for the police department, and that the advisory board is simply that advisory board. And I also wanted to point out that the ordinance that created you guys was brought forth by Don Overcash, who's the liaison to the police, the PCAB. So it was his objective to create you guys, but that was during. So it's my public comment that the PC. I'm sorry, I'm getting the initials mixed up. You guys are the Community Trust Commission. Okay, so that's a commission, and set up by Don during his campaign. So while you're here tonight, I think it's important to remember what you did. And you guys have the job of creating some kind of trust in a city where we have a city charter that makes no reference to oversight or accountability at all. So that's kind of my comment to it. Thank you.
Do we have any more public comment?
Hi. Hello. My name is Deborah Short. I wrote that.
Oh, do you have
Okay. My name is Deborah Desura Short, and I wrote that email. There is oversight in this city, and it's sitting right there. And so I want that to be really clear. I've gone to police board meetings. There is no accountability there. There is no accountability in Loveland. I'm happy that you guys want to address that. I hope that you do address it. If you have any questions about the email, that email was a test because I believed that there was really no public comment. I believed when I saw Jordan asking for comment time and time again and no one was calling, I knew that something was going on. So that was the test. Thank you.
Okay, thank you. Okay, so next we have the CIRSA presentation, and let's get this going so we don't have to keep you waiting anymore.
Everyone can hear me? Can you hear me online? Commissioners, staff, thank you very much for inviting me. My name is Sam Wright, and I'm General Counsel for CIRSA. CIRSA is an acronym for the Colorado. Yes, sir.
Could you lift the microphone up on top?
Better? Okay, thanks. Again, my name is Sam Light. I'm General Counsel for CIRSA, which is the Colorado Intergovernmental Risk Sharing Agency. We are the city's insurer for property and casualty liability coverage. Thank you for the invitation to come visit with you this evening. I do have a PowerPoint presentation, and I'm going to move through as quickly as I can and then open it up for questions. I was asked to give you a, kind of a 40,000 foot overview of what the law enforcement liability litigation or claim process looks like. So we'll go through the slides. All litigation has all sorts of moving parts, but I'm going to run through a scenario just to kind of highlight the steps in the litigation process. I do want to make one disclaimer, though I am an attorney and general counsel for CIRSA. This is not an attorney-client communication. When we get to the questions part later, if you have questions for me, that's fine, with a couple of caveats. First, if it's a question about something you've got going on right here, right now in Loveland, for which you need legal advice, then your city attorney's office is the place for that. And additionally, as was mentioned at the previous meeting, just so I get the elephant in the room on the table, I'm not going to address questions about the Garner litigation. The current status of that case is that the settlement agreement has not yet been fully finalized and implemented, so it would be inappropriate for me to comment on that. Just so you know who I am and where I am in relation to that, I'm not one of the litigation defense attorneys involved in that claim. I am general counsel, corporate counsel for CIRSA, so I deal with issues at a 40,000 foot level for our organization as an entity. I provide member services, member trainings, deal with high level issues related to our defense panel of attorneys, but I don't actually litigate any specific claims. I leave that to the folks who do the litigation work for us. Okay, next slide. Thank you, Justine. Next slide. Just a little bit more about CIRSA. So we're what's called a public entity self-insurance pool. We are not a commercial insurance company. We were formed pursuant to Colorado statute back in the early 1980s. Our only book of business, the only type of insurance that we write, is for Colorado cities and towns and affiliated entities like housing authorities or renewal authorities, those kinds of things. That's our whole book of business. We're very proud of that. We are owned and controlled by our members. Right now we have 282 member municipalities. The types of coverages that we provide for the city include general liability coverage, public officials liability coverage for elected and appointed officials. So probably not your first question when you got appointed to the commission, but when you got appointed to the commission, you became an insured under the CIRSA liability policy. Another thread of coverage that we provide is what's called law enforcement liability coverage. We'll talk about that this evening, but the LEL coverage, as I call it, provides coverage for claims against law enforcement officers arising from law enforcement activities. As I mentioned, there are about 282 towns and cities within the pool. With regard to our LEL coverage, our book of business is we provide insurance for all those law enforcement agencies that are operated by our members. And as just a straight up data point, that means we provide insurance coverage for about 3,900 or 4,000 peace officers around the state of Colorado. Okay, next slide. Before I dig into actually our role in the claims process, I thought as a background point, you may have touched on this at earlier meetings, but just give you a little bit of context about law enforcement liability responsibilities under state law. So by law, public entities are required to defend and indemnify their employees. That's actually both officers and employees. There's a statute that says that the city, and by extension its insurance provider, right, are required to defend and indemnify employees against tort liability arising from acts or omissions within the scope of employment and performance of duties. That next bullet there gives you the source of that, but there are a couple of them, and they kind of overlap a little bit in the area of law enforcement. We've got the Colorado Governmental Immunity Act that applies to all public entity officials and employees in Colorado. There's additionally a statute that speaks specifically to liability of peace officers that I've listed there. And then, as you know from news, the last 2 years, there were two pieces of police reform legislation that touched specifically on law enforcement liability, created a new constitutional cause of action under the Colorado Constitution. That also speaks to employer obligations for defense and indemnification. That's the peace officer accountability legislation. There are certain exceptions to this obligation for an employer to defend and indemnify its employees, including police officers. That includes, these statutory exceptions include willful and wanton conduct and criminal conduct. Those correspond to exclusions in liability policies. For example, the CIRSA liability policy includes an exclusion for liability that flows from a criminal act for which a person has been convicted. And that's true whether it's a peace officer or any public employee. If an action is brought under state law, under the state tort statute, the concept of governmental immunity applies, and there could be a bar to suit on that basis. If there's not a bar under governmental immunity under state law, then if it's a state cause of action under the state tort statute, there are limits on the amount of damages that can be recovered. Those state law concepts are not applicable to federal claims, nor are they applicable to the new state constitutional cause of action that was authorized by Senate Bill 2217 and House Bill 1250. Okay. Let's go ahead and flip over to the next slide. All right, that then, those background concepts, right, of course, an obligation of the employer to defend and indemnify the public employee, that translates to the risk allocation or risk resourcing or risk transfer mechanism of insurance, right? And all public entities, never heard of one that doesn't have it, but all public entities, right, then have liability coverage. A standard line of coverage that for public entities that provide law enforcement is the LEL line of coverage. And that's the standard line of coverage for law enforcement activities, which is a defined term. Most of them are similar in their definition, but paraphrasing our language at CIRSA, but it's similar to most policies, say that that coverage is for activities in the scope of duty as a peace officer or a reserve officer or as someone representing a law enforcement agency that results in bodily injury, property damage, personal injury, or a violation of civil rights. So that's the technical point of attachment for coverage for a law enforcement liability claim. Depending on what the insured chooses as their insurance program, the financial aspects of coverage, is that echo okay with everyone? I feel like the microphones have a little feedback. Okay, okay.
Okay online.
All right, great. The financial aspects of the coverage typically include these components. There's a retention or a deductible payable by the insured. For our members, for all public entities, those retentions or deductibles vary upon what's offered by the insurer and what's desired by the insured member. Deductibles in CIRSA, for example, range everywhere from $1,000 up to $250,000. Okay. The city of Loveland on this line of coverage, their deductible, year deductible is $250,000. So you have a deductible payable by the insured. You have a primary layer payable by the primary insurer, that's CIRSA. So we then take a next level of financial exposure on a claim. And then insurers, they buy insurance, right? And that's either excess insurance or reinsurance. And the excess layer above the primary insurer's retention is usually payable by the excess insurer or the reinsurer. In general liability and law enforcement liability lines, it's typical that it's not excess coverage, it's reinsurance under a policy that essentially what we call in my world follows form, which means the reinsurance provides the same coverages. All right, think of it as two circles that completely overlap each other, right? So the coverage that you provide at the primary level is the same coverage provided at the reinsurance layer, and that's the reinsurer. You get into their layer above the primary insurer's retention, okay? So as you can see for that, we got multiple parties potentially involved in the financial aspects of a claim, the insured, the primary insurer, and the reinsurer. As a matter of contract, it's usually the case under that sort of structure that the primary insurer has the right, the contractual right to settle or defend the claim. But in doing that, perspective is given right to all the interests of the defendants involved, and particularly at CIRSA, our claims management approach is whenever possible, we try to use a team approach and make sure that even if we have to respectfully agree to disagree on a certain point, we try to make sure we have the perspectives of every single party whose interest is at stake in the litigation. If the loss appears to fall solely within the city or member's retention, then at that layer, it's essentially the insured or member's dollars. So same kind of team approach, but there may be more weight given, right? The city has more weight, perhaps in resolution of a matter at its retention level, okay? Now, having said that, in the law enforcement world and in other city operations or exposures, we call them, there are mandatory reporting requirements, where irrespective of the financial exposure, even if it's, you look at it and you say, well, based on what we know about this case right now, this claim is only worth $5,000. If it involves certain operations or activities, it's required to be reported to the reinsurers, and they will ask that they get reports periodically throughout the life of the claim, just based on the type of incident occurred. I will tell you, in the reinsurance markets writ large at a 40,000 foot level across the nation, there are reinsurers putting more requirements on primary insurers and their insureds to do more and earlier reporting of claims that involve law enforcement activities. Okay, next slide, please. All right, so to explain the litigation process, I thought it'd be helpful just to kind of follow the hypothetical progression of a claim from, from the day of the incident all the way through the civil litigation process. So for that purpose, we'll pretend that we've got a law enforcement use of force incident occurring today, December 20th. And the reason I want to attach dates to it, is general dates, is to give you kind of a sense of the timelines involved as we go through this process. But recognize that there's so many things that can cause those timelines almost invariably to extend. Once in a miraculous time, litigation deadlines contract, but it's usually that they get more drawn out. So next slide. So, you have your incident in the field that occurs on December 20th. You have some things that go on immediately. This is more on the law enforcement operations side, but there's the drafting of the police reports, and then certain post-incident things begin to happen, right, that will become documentary or video or other evidence that will be reviewed later in the claim. And that's things like the agency may move forward, right, with its own internal use of force investigation. There'll be requirements under police operations manual, right, and operations generally for evidence preservation. You might have, particularly if it's a high profile incident, you may be getting requests for information almost immediately that need to be handled through public information office or whatever resources you have for that. Depending on the incident and what your police manual says, you may have a citizen complaint. So all those things are going on perhaps concurrently, and before we may see the claim. It may be that we've gotten the claim already or not. And then in a use of force case, the CRIT process, the blue team investigation process is going on then concurrently with those other administrative things. Next slide. All right, so to show you how the sort of the civil claim process works, the next thing that would typically happen in terms of formal steps towards litigation is that we will typically see what's called a notice of claim. Okay, there's a statutory reason for that. Under the state law that governs state tort claims against public entities, the claimant has to file, it's required by law to file a notice of claim within 182 days after the incident. So using the last possible date under our hypothetical, the notices of claim is due by June of 2022. That only applies to state tort claims. If the claimant fails to give that notice of claim, then their state tort claims are barred, right? If, for example, if the claimant thought that they had a claim of assault against the peace officer, if they didn't give their statutory notice within the time frame, then that claim is barred. Doesn't mean other types of claims aren't barred, but it means that state tort claim is done. Now, if not yet previously done, this is usually the first point in time when our member, when our insured receives a notice of claim, either from the claimant or an attorney representing the claimant. If it wasn't done sooner, that's usually the first formal time that that'll be turned into us as the insurer, right? And then we establish a claim file, we assign an adjuster, and we assign defense panel to that, okay? Excuse me, defense attorney. Defense attorneys for our claims, irrespective of whatever the type of operation is an attorney assigned from our panel attorneys. We call them our defense panel, okay? Among the things that we do at that point in time is we open a claim file, we assign a claim number, we assign an adjuster, and we assign defense counsel, okay? And of course, then we're all reading the notice of claim to see what the claimant's perspective is of the incident. Next slide. All right. Technically, what then happens is once they have that notice of claim, the claimant actually can't bring their lawsuit until they either get a response back to their notice or 90 days has passed, right? But what we typically do, or adjusters will do, and defense counsel is during that 90-day period, they'll meet with the potential defendants. The notice of claim is not a lawsuit. It's a prerequisite to a lawsuit. So at that point in time, we're taking in the notice of claim and we're doing some initial evaluation of what the potential claims look like. That's both on a technical side and on a substantive side. On the technical side, we'll be looking at things like, was the notice timely, right? Or does the claimant potentially have defects in their claim already because the notice is late? We may look at the notice and say, well, what type of things are they alleging in the notice? Are they all things that might be subject to governmental immunity? We also begin looking at the issue of whether there's coverage for the potential defendants involved. If it is a certain type of operation, or it looks like it may be a very significant high dollar claim, then we're obligated to report that to our reinsurer. It's at this point in time that we begin and likely will set some initial case reserves. We may need to gather more information. For those of you not operating in the insurance world, the reserve is a fancy word, of course, for an estimated cost of handling the defense and potential indemnity obligation on a claim. So it's really an educated guess of what is the potential cost, right, of this claim. Very important in the insurance world for reasons that I'll talk about in a second. Now, even though it's pre-litigation, particularly if there's interest on the other side, and there's interest among the potential defendants and the insured city or town, we may open at that point in time a discussion about resolution, right? We can, why not solve claims pre-litigation if that can be done at a point where everyone's accepting of that. Now, sometimes it just doesn't happen. Right? We get a claim demand that's way up here. We've got an initial case assessment that's way down here, and there's not going to be a meeting of the minds that early in the process. But if people are amenable to talking, then we'll try and facilitate a discussion to see if that can happen. On the other hand, if it's apparent right away that this is the position and we're here on that, then that notice period usually runs without a lot of substantive discussion and potential resolution. Next slide. All right, next step then, the notice period has run. Now the claimant can, if desired, bring their lawsuit. Tort claims under state law have to be filed within 1 year of the incident. So in our hypothetical, by December 20th, 2022. Most federal claims have to be brought within 2 years of the incident. So by December of 2023. In filing the lawsuit, of course, you have to file with the court and then you have to serve the defendants. That's a formal process unless service of process is waived. And then once service is affected on the defendants, that triggers an obligation to respond to the complaint somehow. In practical terms, if we have a claim that involves the insured city or town, plus a number of potential defendants, number of officers. Quite frankly, rather than having a little bit of initial chaos about when was service done and how was it done, we might make mutually agreed upon arrangements for service of process, just so starting the claim, we know everybody's on the same page about what the deadlines are. Even if that doesn't happen and the defendants are served, our defense counsel typically will call up the attorney for the claimant and say, look, we're just getting assigned to this case. We need some more time to evaluate, talk to our insureds about this issue, so can we agree upon a response date, okay? But if we assume that the lawsuit was filed on the last possible day, we have an incident that occurs today, lawsuit would come in December 19th of 2022, okay? Next slide. All right, at this early stage, there is an obligation that's coming up regarding responding to the lawsuit, but at this point, even starting with when we get notice of the incident or the claim, defense attorneys or interviewing clients, we're gathering evidence, might have a reminder to folks who are on the governing body, right, or to staff involved, and just a reminder that says, now that we're in litigation mode, recognize that even well-intentioned statements might be misconstrued or might be misinterpreted as some type of admission against interest. So that's why, and I think this point was touched on at your last meeting, when we're in pending litigation, we kind of ask that people be very circumspect, and we have a very controlled steps for communication, so that there's not, right, a misstep in making something that can be used against individual defendants or the entity for purposes of proving liability, okay? At this early point in time, we then will usually get a letter out to the insured acknowledging, hey, we got the lawsuit, and we will send what's called a reservation of rights letter, okay? Not a fun letter to get, but it's a very important letter in the insurance world, because what it does is it acknowledges that, tells the insured, all right, this claim in a reservation of rights, we're saying that there is some trigger point for coverage, right? So we're saying you have coverage, here's your defense attorney, now here are some of the things you need to know about your insurance coverage, and that's how we'll explain how coverage attaches, and we'll explain the potential exclusions that could apply if there's a court determination made at a later date, and one of those exclusions could be applicable, okay? And in the insurance world, the duty to defend is broader than the duty to indemnify. So our obligation to defend will be triggered, but we'll then need to send out a reservation of rights to explain that, if someone says, for example, I'm alleging willful and wanton conduct in our reservation of rights letter, we might say then, just so you know, under the policy document, there's an exclusion for willful and wanton conduct. So if it's later adjudicated that the liability is actually the result of willful and wanton conduct, then we reserve our right to not provide indemnity coverage if we so choose, okay? So that's how those work. The other thing we have to look at in multiple defendant cases is figure out where the interests are as best we can at the initial stages to determine whether, in the event of multiple defendants, do we need multiple attorneys, so that each attorney who might have a potential conflict with other defendants has separate counsel, okay? At this point, our adjusters are going full bore, right? They're beginning to set up the claim file, the communications tree. They're dealing with reporting to the reinsurer. They're beginning to receive from the law enforcement agency or the insured all this information, right? We're going to ask for police reports. Do you have other reports? Give us the use of force report. Do you have the police mail? All those things we start looking at in terms of having eyes and ears on all the documentation that can influence the claim. Next slide. All right, I just want to sidetrack a hair more about adjusting. So the claims adjuster, in our situation, our claims adjusters are SURSA employees. Our claims adjusters have significant amount of experience. Collectively, they have decades of experience in handling public entity claims, but they basically serve as the eyes and ears to help monitor the progress of the claim. They'll handle reserving, reporting, and documentation issues. They'll also help with the initial reserving of the claim. In that regard, just to be respectful of your time, our executive director, Tammy Tenoya, wrote a nice article about the role of the adjuster in handling a claim. And so I'm going to pass that out, and you can take a look at that at your leisure. If I don't have enough, I hope I got enough copies there. I think I do, but if I don't, we'll make sure everyone gets a copy. But that's the adjuster's role in helping keep track of things and dealing with billing, setting initial case reserves, and so on. Okay, next slide. In the progression of our lawsuit, the service of the lawsuit sets up an obligation to respond. It's essentially the case that you've got two options in the initial response to a lawsuit. You either answer the complaint and you admit things where you can, where you disagree with an allegation, you deny those, or if there's some other technical things. Or you can file a motion to dismiss. In the public entity world, whether it's law enforcement liability or any other type of public entity operation, a motion to dismiss is something that we very seriously consider because of the concepts of governmental immunity and qualified immunity. Those concepts are there. I know they're hotly debated topics, but in the defense world, in part what they do is allocate judicial resources efficiently. So if we have a defense, right, and a legitimate reason for asserting the defense of qualified immunity or governmental immunity, we'll consult with all the parties involved on the defense side, and we'll decide, relying heavily on the initial assessment of our defense attorney, whether we should file a motion to dismiss. And what that then does is it depends on the judge in part, but it puts some of the other litigation activities on hold until we have that initial question answered as to whether or not there is immunity, okay? And again, the concept of immunity, there's several different types of immunity, but in law enforcement liability, there's basically two. There's governmental immunity under state law. That's the same immunity that applies to all types of governmental operations. And there's potentially qualified immunity for federal claims, okay? At this early stage, we might, if we sense that there's interest, try some more formal attempt at resolution like a mediation. And then once we have the formal lawsuit filed, as our adjusters are keeping their eyes and ears on things, we make some adjustments in the reserve. Okay, next slide. I see a hand waving. I don't know if you want to handle that now or just wait. Okay.
Yeah.
I'll go back up here in just a minute, then I'll open it up for questions. The most extended portion of the litigation process is the discovery phase. So both sides are going to be giving to the other side written discovery where we ask for documents or ask questions, depositions, critical phase in the litigation process where both the plaintiff and most of that all the defendants are deposed. There may be experts retained at that point. In the law enforcement arena, we may have, for example, experts retained on either side on the use of force. In terms of each side looking at, do we need an expert to help explain why force was used? Plaintiff side may be saying we want a use of force expert to help explain why, in our view, the use of force was not reasonable. So you can see how those things come into play. We have other experts on medical issues, looking at medical records, and so on. And then again, as we're in the discovery phase, we may additionally continue to look at settlement issues. Okay? Next slide. By the way, we're into December. We're 2 years out probably by the time we've wrapped up, 2 years from incident, by the time we've wrapped up the initial discovery. It depends on how many issues crop up during discovery. A couple of comments about valuation, right? How does one determine the value? How does one set reserves? Some of this is mentioned in that article there, but things that we look at, for example, strengths and weaknesses of the legal theories being asserted in the case.
Pardon me, I'm so sorry to interrupt, presenter. This is Commissioner Schneider. I just want to make a note that we are running out of time, and I do want to ensure that we have time for commissioners to ask questions. I know Chair Pryor had his hand up too, so I would defer to any comment he has as well.
I was just going to basically put this in Sarah's hands, and because I agree, especially because we don't know if extending this meeting is going to be a for sure thing. So Sarah, with that, it's your decision at the end of the day, since you are the acting chair today, but we have 18 minutes until we would have to adjourn if we did not extend the meeting.
Okay, can we quickly make a motion to extend till 8:30? An additional half an hour today. So I would like to motion that we extend till 8:30 so we can finish this conversation.
I second the motion.
All in favor? Okay, would you please continue, Mr. Light?
Keep going, Madam Vice
Yes,
Chair?
please.
Okay. So some of the points about how claims are valued is in the article that was handed out. This slide just lists some of those things. We'll look at strengths and weaknesses of the legal theory. That starts as early as the notice of claim or the filing of the complaint, right? And we'll be looking to our defense attorneys on the immunity question, whether it's particularly with the federal claims, right? We're going to be looking for an initial assessment of, hey, based on the facts, as we know them right now, is there a constitutional violation? Now, I think whether it's law, medicine, or engineering, we used to think that maybe there's just a easy, black and white answer to those questions, but they don't come in that way when we get our defense attorney evaluations. They're just like engineering and medicine. Sometimes there's not a black and white answer, and that assessment that we'll get from our attorneys will be a range of probability of the likelihood of success or the likelihood of failure, right, with regard to an argument about was there a constitutional violation. So that's just part of what we weigh in the mix. We'll look at circumstances unique to the parties, right? The history of the defendants involved. We'll look at whether or not the claimant is a sympathetic claimant and a good witness with regard to entity liability. We'll look at issues about training. We'll look at the actual methods used. In this day and age, we look at a lot of body camera footage, right, in helping assess claims. But one of the caveats about body camera video is it's going to show one angle. If we have multiple officers with multi-body cameras, we may be fortunate enough to have different angles on what's going on. So body cameras tell a story, but they also tell it only from the perspectives from where the body camera was located. Economics of the claim are obviously the biggest issue in valuing the claim. What are the actual damages look like? Things like medical treatment, lost wages. What does the non-economic damages picture look like? The potential for an award of pain and suffering or punitive damages, which are not covered, by the way. Punitive damages are not covered under Colorado law. And then in the civil rights world, the potential exposure to legal fees is a big component of the potential exposure. This day and age, a rough rule of thumb is that to take either a law enforcement civil rights claim, a complex one, or by analogy, sometimes like complex civil rights litigation regarding land use matters, those kinds of things are several hundreds of thousands of dollars to take through trial. If it's a federal constitutional claim under USC 42 USC 1983, then there's also a potential risk that if the plaintiff prevails, and they don't have to prevail on all of their claims, but if they prepare on a substantive claim, prevail to some extent, then they're entitled to their attorney's fees as well. So the exposure side, we're looking at both costs to defend as well as the potential risk of a award of attorney's fees against our insured. Okay, next slide. All right, getting back on track to our timeline. So after we're done with discovery, we're going to look at what that showed, and we're going to look at the next substantive decision point. Is this the kind of case where one can file a motion for summary judgment to attempt to resolve some or all of the claims? You can only get a motion for summary judgment granted if there are no factual disputes, which can be a difficult thing in a law enforcement liability case. Easy to identify the timelines for the work that we and defense attorneys and plaintiffs' attorneys have to do around a motion for summary judgment. That can be fully briefed in approximately a month and a half or 2 months. But the thing we do not control is the calendar of the magistrate judge or the other judge handling the case. So we don't know how long it's going to be from the time that motion is ready for ruling until it's actually ruled on. But it can take six months is pretty common, if not more time. Some of the things that might happen after the motion for summary judgment, if we think it's viable, is filed, there might be more discussion around settlement, right? Either side may think, hey, we've got some risk in this, or the other side has some risk in this, so we might attempt Again, resolution. The other thing not mentioned in the slide is sometimes we may file what's called an offer of judgment. Offer of judgment is a formal statement to the court and to the plaintiff that basically says, we offer this amount of money as a formal offer of judgment. And the way the court rule works is if the plaintiff decides not to accept that and goes to trial, but receives a lesser award, they still win, but they receive a lesser award, that cuts off their recovery of attorney's fees from the point in time that the offer of judgment is made through the rest of the proceedings. Okay. On the other hand, if they win more than the offer of judgment at trial, right, then there's no cutoff there. So that's just a court rule that the courts have adopted to help encourage attempts at settlement. Okay. If the case isn't resolved on a summary judgment motion, then we're beginning to work on pretrial stuff that takes us through a couple more months of prep. Next slide. Then we'll have our trial. Depending on the claims involved, we're either going to be in state or federal court. Okay. Just to step back out of the weeds a little bit, a 40,000-foot level. Before the adoption of Senate Bill 15 and House Bill 1250, almost invariably law enforcement liability litigation was filed in federal court with a mix of federal and state claims. We don't know yet what the long-term effect of the police reform liability legislation will be. We are still seeing most of the cases filed in federal court. That may continue to be the trend, or it may be that we see more cases in state court. We just don't know yet. Okay. Trial in law enforcement liability claims or any complex litigation is minimum 3, 5, more like 7, 10 day trial. Okay. Let's see. Next slide. You're going to have your, to go all the way through trial, you get your verdict, and what the findings are in the verdict is going to dictate where you end up with regard to coverage, right? It depends what the theory of recovery is. If either party is unhappy with the outcome of the trial, they have rights to make appeals. Those appeals are usually due within a month or two after the trial, but resolving an appeal, depending how far you go with it, can be a 12 to 18 month to get through the Court of Appeals, and even longer if you have a Supreme Court that decides to take up an issue, because appeals beyond the Court of Appeals level are discretionary, not mandatory. Okay. Next slide. So as you can see, that takes us to a pretty long timeline, right? Under our scenario there, the law enforcement liability claim from incident through trial took approximately 30 months, right? And that's not including any Supreme Court review. Stepping back and just giving you some thoughts on broad trends. The costs of claims are rising. That's true generally, but that's also particularly true for law enforcement. Claims, some people ask us at SURSO, so what's the litigation effect of the new police reform legislation? We don't know yet. It's too early. As a timeline, it takes 30 months to get a case to trial. So for the first year, frankly, after adoption of Senate Bill 217, most of the claims we were seeing and continue to see are being filed in federal court, and they haven't really, those cases haven't developed yet. There are some different push points and pull points in litigation now. One of the things the police reform legislation did is it puts peace officers post-certification at risk if they're found civilly liable in a claim, so that will probably introduce a new dynamic. It's yet unknown what's going to happen at the federal level with qualified immunity. So for the time being, there is qualified immunity in place at the federal court level for federal claims, and we will assert that defense when appropriate to do that, right? But it's too early to know what the ultimate effects of police reform legislation will be on the law enforcement liability litigation world. Yes.
We're running low on time.
Yep.
Wondering how many slides you had left, and then
That was the last slide and the last bullet. Yeah. I would just then point out one thing about the other dynamic going on, because litigation and claims is the downstream end, of an incident, and the upstream side of that, of course, is prevention, risk management, and those kinds of things. So I think that's a key focal point as well. Just so you know, with respect to what SORSA does for that, we have a risk management department that does, if our members so ask, we do certain types of things in the law enforcement arena. We do, for example, around the state law enforcement roundtables, where we invite command staff from agencies to come and talk to our defense attorneys with questions that they have about the law enforcement liability world, at least from defense attorneys' perspective. So with that, I'll stop there. I hope the overview was helpful to you all. I'm certainly happy to answer any questions.
We have 15 minutes. I would like to please ask the commission to keep it brief and relevant. And he asked us that we do not bring up things directly involving the Gardner case, so let's not do that. So we already have a list of people. So if you raise your hand, we'll write it down and then you'll be in order. So first, Commissioner Stoddard.
Thank you very much. Quick question. I couldn't see the slides real well, but did your investigation, the insurance company, insurance carrier's investigation, start after the incident or after the notice of claim?
After we get notice from our insured that there's a claim or a potential claim.
So would that typically be close to the time of the incident?
Not always, but sometimes. Yeah. And the other thing that may be going on is if there are IAs and blue team investigations going on, we may deliberately say, let's wait until that information comes in.
But you would probably know that that is going on.
Yeah.
Okay.
We probably would. Yep.
Hi, thank you. Has our city, this insurer for SORSA, taken the advice and recommendation for risk management procedures?
We just make the resources available. So
You don't know if our specific city has taken advantage of those resources.
I don't know off the top of my head one way or the other. Yeah.
How could we find that out?
I would have to defer. I don't know. I'd have to see. I don't know if SORSA keeps rosters of attendance for those. I know we have those roundtables around the state. I don't know.
So it's just the roundtables. That's the only type of recommendations for any kind of risk management as far as training policies. You don't offer that advice to your...
We make other resources available that are around there. If you go to SORSA.org and click on our law enforcement liability page, you'll see, for example, general articles that we've written about these kinds of issues. But we generally, with regard to operational issues, there are other resources out there that I'm sure your department utilizes.
We have to ask our risk management department if they've taken advantage of those.
Yeah, unless other staff has a suggestion on that. Yeah.
Okay, next we'll have Catherine, Natalie, then myself, and then Catherine. We do see your hand up.
Thank you. That was an excellent presentation. It would probably be a 2-day continuing legal education course. So if that's at 40,000, can you go up to 75,000 and just explain, kind of just in lay terms, the difference between a claim under the law enforcement liability coverage, and it's probably buried in the definition of the law enforcement activities, the difference between the liability of an officer who is insured as an employee of the city, and the non-derivative, the standalone liability of a municipal entity, the city itself, in a law enforcement liability claim.
Yes, with the caveat that that's a 2-day COE as well, and in very, very general terms. So we're here, just to keep it simple, I'll talk primarily about federal civil rights liability. So under that concept, that statute that I mentioned, section 1983, can impose liability individually on a governmental actor for a violation of federally protected rights. So that's a point of attachment of potential personal liability. Now, with regard to public entity liability, right, that's a different theory of liability. In order to attach liability to the entity, typically you have to demonstrate something like policy, right, or pattern or practice type of thing, right, to show that the entity itself somehow played a role in the underlying circumstances that gave rise to the liability, right? So that's why you hear this phrase sometimes in the popular press about pattern and practice liability or Monell liability. That's the U.S. Supreme Court case under which the U.S. Supreme Court determined that you can have not individual liability, but entity liability against an entity, but you have to demonstrate that somehow their involvement was at the policy-making level that gave rise to the liability. So does that help in a nutshell? Okay.
It did, thank you. And I just had, oops, I'm not supposed to do that. One kind of question, I think, so that we don't stray too far outside of, what we can, but, the insurer is a third party in communications, and, their lawyer-client privileges. And if you could just address, because I'm sure this, this, what is, if you could state kind of succinctly what the Colorado law is on the privilege between an insurer and an insured, and if those are if there's limits to the rules of confidentiality.
Yeah, there's a whole body of case law again on that. It's not 2 days, but it's probably a half day. And part of this also, I should tell you that among the interested parties too, sometimes that Circe in its own right hires its own attorneys to protect its interest because it's a separate entity itself. But in very general terms, you can attach attorney-client privilege to documents that you have defense counsel preparing in defense of a claim. That's a privilege that's available no matter what the type of claim, right? If it's attorney work product preparing for the defense of a claim, then that privilege can attach, okay? In the insurance world, there are additional protections or privileges for certain aspects of claims files as well, particularly that those documents and materials that speak to the mental processes of the adjusters and insurers involved in determining how they arrive at the value of the claim. Of course, all settlement discussions can be protected under rules that apply to settlement discussions, those kinds of things. So is that a helpful thumbnail?
It is, and the investigative files, the adjusters' files, not the their mental impressions, but their claims file, their adjusters' files.
Yeah, generally the adjuster's file is privileged, but I'll be frank and say that's a little bit too broad a brush, because if there's information in the claim file that actually appears in other public records, then, if it's already in the public realm, the mere fact that it's in the adjuster's file doesn't mean that it's not available through discovery or something like that. Okay.
And just, do you think we could get the PowerPoint slides?
Yeah.
I think that was a yes. Okay, thank you.
Yep. Yeah. And also, please let Justine know if you didn't get a copy of our article about the adjuster's role, and we'll make sure you get that as well. So, oh, it's okay. So we'll get some more of those out.
Okay, so I then had a quick question, and my question had to do with how often are these cases dismissed? Specifically, like the law enforcement ones that come to you, how often do they come in and then just get dismissed? Just curious to see how many.
I'm sorry, I didn't prepare for that. I don't have that data point, but I will tell you, just in general terms, that a fair number of state tort and federal claims will be dismissed on a motion to dismiss on immunity grounds. Having said that, I will tell you that in general, we're sensing that federal judges are becoming less inclined to dismiss cases on immunity grounds pursuant to a motion to dismiss. That a trend is they're at least allowing those to go to motion for summary judgment. Okay, I'm sorry to be so guarded about that. I did it, and I should have wrote the numbers down. I did view a CLE where an attorney out of California was actually given statistics, but I can say this. I don't want to misquote those statistics, but they weren't out of the 10th Circuit, which is our circuit. So I really don't have at my fingertips credible data on the percentages for MTDs, motions to dismiss, for LEL claims here out of the 10th Circuit.
All right, we have Catherine and then Mike.
Hi, thank you so much for the presentation. I appreciate it. Just real quickly, does CIRSA or even preferably, is there a nationwide insurance body that keeps stats regarding claims paid per department, so that would be able to compare Loveland Police Department to other departments nationwide or even statewide year over year that address things like excessive use of force?
I'm not aware one that I can represent to you keeps that kind of statistics broadly. I know there are groups that try to track verdicts and settlements on those kinds of things, but I can't, say that they uniformly across the board keep track of all settlements, all judgments. Just to give you an example, and I'll name a name because I was looking at it. It's a foundation called the Thurgood Marshall Legal Justice Center. I apologize if I got their name wrong, but they of late have begun tracking verdicts and settlements. But I can't say it's a rigorous statistical reporting of claims.
I apologize to interrupt, but I did not talk. I don't think I said verdicts and settlements. I was just asking about claims. Very specifically, don't you use risk management to monitor how claims are coming in?
Oh, I'm sorry. Well, we keep our own data on the number of claims of all categories that we get. Sure. Yeah. And
would we be able to get any of that from you? From CIRSA?
I need to check with our folks about that and see what I can share with you. Yeah.
Okay. Thank you.
Okay.
Okay, so we have Mike and then Tara, and then we'll probably call it, if that's what, Patty. Sorry, Patty. Mike?
Yeah, and I'm sorry, before I answer that, I would also just, only because I think you can probably find it, just some information, not lots and lots of it, and not a lot of discussion of the methodology, but there are some studies out there that will give you just general numbers of the number of law enforcement claims filed, and give you some sense of average cost per claim. But I can't speak now to how broad those are or what the methodology they use are. But I apologize that I misunderstood your question. It's absolutely the case that reinsurers do track the claims that they have and their average and mean cost per claim and so on and so forth. Yeah.
Just have just kind of a question on the kind of economics.
Yeah.
So, Loveland is a city of 75, 80, that we're kind of in that range somewhere. What do we pay? And maybe it's a question for the city manager, but what are our annual premiums?
I don't have that either on the top.
Well, I just out of curiosity, for an average city, what do cities typically pay in terms of annual premium?
Yeah, there's a one size fits all because it depends on their exposures, right? We'll have some cities, for example, we have a large metro area down south that doesn't have a law enforcement exposure because they contract with the county for all their law enforcement. So, but the law enforcement exposure line itself will create a significant percentage component of the overall cost of insurance, like upwards of 40 to 50% of the general liability cost. Yeah.
Sure. I just kind of trying to understand for perspective. Are we talking about hundreds of thousands of dollars a year in that range, maybe, depending on the size, even upwards of $1 million in premiums?
Yes.
For assuming that it is across the board. So now, I look at it kind of through the lens of my own, having, just the insurance that I carry.
Right.
If I get in 5 accidents a year, my insurance company is going to come back and they're going to charge me, raise my rates,
right,
or drop me, perhaps. I don't know that. So, the part of the question I was trying to understand is just, as a citizen, as a taxpayer, as a resident of the community, when these incidents occur, they have an impact on our budget. When payouts are made, I don't want to be specific,
right.
But so how does that affect the question? Like, it's at what point is do you, from just a fiduciary, do you go back to a city and say, look, if you don't take active steps, we're going to have to raise your rates, or we're going to drop this coverage, or does that type of kind of negotiation, how does that piece work?
Yeah, there is experience rating, right? I'm just going to talk about the general insurance principle. So insurers will look at loss experience. Depending on the insurer, they may or may not have a mechanism for flattening that so that the hit is not all in one coverage period. In other words, attempting to smooth that out. Depending on the insurer, it may be that they'll let it smooth out for a certain number of years, but then if the loss experience continues past years 2, 3, 4, or 5, then there'll be a higher rate increase in that regard. So the way we rate and charge for the exposure depends on what the exposure is. For example, general liability exposures are rated and charged just based on a total operating expense basis. Law enforcement liability is rated and charged based on a per officer basis, okay? But it's absolutely the case that insurers will look at, and then depending on their underwriting and rating process, they will look at how they address loss experience, but loss experience is addressed, yeah.
If I could, one more question, if that's okay. So having worked for a public body or multiple public bodies, I know that there are elements of risk, that processes and procedures that we have to go through. I was not a police officer, but I even know in the roles I've had that there are things in different process and procedures we need to follow, and accounting and documenting. I'm assuming on the legal side that must be fairly robust. I'm trying to understand that what would be the requirements as an insurer to say you must have these protocols in place, or you are required to take these steps or provide these types of training as a condition of, or in exchange for discounts on insurance, on premiums, or does that occur? I guess is what I'm trying to understand, and how much of that is something that could we have access to? I mean, what are those requirements? As part of our insurance that are applied to this.
Yeah, in a general sense, it does happen in the insurance world, right? That there be a premium or contribution discount for doing this or that. It serves for its own part. A couple of years ago, we had much more what I call prescriptive audit standards. We tried to shorten those. We have a very diverse membership, 282 members. In the law enforcement realm, a lot of best practices and operational requirements are driven by statute, or if they're looking for maintaining or achieving accreditation, it's driven by professional standards. So we don't do a lot of that, but we try to put resources out there or point members in the direction of resources that might help them, whatever the operation may be, whether it's running a police department or a park and rec department or so on and so forth, okay?
You would rely then more, I mean, what you're implying is that you rely more on kind of third-party accreditation, or that make as thresholds for kind of premium reductions or however.
Right, or in making recommendations or suggestions when the member would like our input on an issue, but we don't have a number of prescriptive standards that essentially requires you must do X, Y, and Z in order to maintain your coverage.
So if we were to ask, I mean, setting aside the incident that we're not to speak of,
yeah,
could we? I mean, is it possible to say, to either probably through the city manager or through the city attorney to ask? Can we have a record of the claims that were filed and settled, or any claims that were filed and settled by the city of Loveland in the last 5 years, 10 years, related to the police department or police activity? Is that something, I'm assuming that's would be a matter of public record. To an extent.
Yeah, CIRSA is not a public entity subject to the general public record statutes. So that kind of information regarding specific claims actually is not public record under Colorado statute. So we can continue a conversation. I guess I would put that in the basket of a request to your city manager and, you know, what's available to respond. So in that regard, if sort of borrowing from your last meeting that I listened to, if you're making a request to the manager's office to look into what can be provided on that, we're happy then to work with your staff to see what we can provide. So yeah, in our world, members do ask for, and we do provide what's called a loss run. But I want to be careful there because it has identifying details that implicate all sorts of interests, you know, not just a financial interest of an insurance company. There may be things there that implicate individual privacy interests. So we need to be careful of that. So, okay.
Okay, so we had 2 more people up, but we're past our 15-minute allocation. Is that all right? But for his question, that's what we have. Yeah. So would you like to continue with the questions or move on our agenda? Okay. Okay, so then I have 4 requests, 3.5 requests that we came up with during this. So may I, one more time. So Terry gets to go.
Okay. Commissioner Hildebrand Shell. It's a real quick question. I was just wondering, so CRSA provides, like when they get their insurance for the city, do you provide the lawyers within that insurance or is it just the payout? Like I'm wondering what it is that you provide for the city that under the policy.
Right. So for a claim that's covered by the city's insurance, if it's a liability claim, and the city turns it in, then we have the right under the insurance policy to settle and defend the claim. We will then assign a defense attorney from our insurance defense panel. We will consult with our member on that choice. We like to, whenever possible, make sure we're in agreement on the defense attorneys being assigned to represent the city and city defendants. And so we have law enforcement, in the law enforcement realm, we have a group of attorneys who specialize in law enforcement liability claims. So that's part of the coverage that's provided, is assigning a defense attorney. And then we assign an adjuster. Our adjusters are CRSA employees. So they're assigned to the claim and they're paid for as part of the portion of the contribution that handles administrative expenses for us as a pool. Yeah, and then our adjusters confirm tasks with defense attorneys. The defense attorney, they say, do we want to, you know, just to use a hypothetical, defense attorney says, we want to get a use of force expert. We'll talk about it, determine whether it's prudent, check with the member, and whether we think that makes sense in defense of the case to get that expert, right? And then we'll have that person hired, and then our adjusters will take care of the billings for that. Again, there's a deductible for the member that applies, right? And as the article explains, we've got to account for every dollar spent, whether it's your deductible or in our layer, because our reinsurer is not going to start putting their money on a claim until they're convinced that all the money you've already spent, right, is appropriate for the claim before their involvement is triggered. Yeah. Okay.
Okay. So just so clear, so like our deductible is $250,000.
Right.
So first, like that would pay for all the adjusters, lawyers, all that. And then if it was like a big case and it went above, then you guys would cover everything else. Is that correct?
Mm-hmm.
Or would all of that be covered and we'd only pay the deductible like towards what the person wins if they win the lawsuit?
No, it's what we call a first dollar retention or first dollar deductible. So as we begin to incur expenses on the claim, the deductible is spent out. Yeah.
Okay. Thank you.
Yeah. Okay. And that's why it's important, particularly with choice of counsel, right? And hiring of additional resources that cost money, that we want to make sure we have a team approach and we're all on board about how those dollars are being spent. Yeah.
So we have had 4 requests, and I'm going to direct this to City Manager Adams to then request from CRSA if possible. So the first one was the use of force claim. So I move to request these, please. Use of force claim, annual premium the slides from today, and what was that called? The loss experience? Loss run, yes. So those 4 things, please. Can I get a second?
Can I have just comment before we move? I actually would be interested in seeing from a premiums. I'd like to be specific and say, I'd like to understand what our premiums that we've paid over the last 10 years annually for the law enforcement component, and I'd like to understand the trend. I'd also like to see the loss run report, understanding with the input from the source attorney that there's sensitive, there perhaps maybe sensitive material that's not available to share with the public. But I think if it does need to be redacted at a minimum, I think what I'd like to see is kind of the amount, the date of the claim, the nature of the claim, and the amount that was paid out. And I think that kind of covers it for me.
So could we please request all of those things?
I just, for the notes, and to be clear, I'd like to make sure that we have those sort of spelled out exactly what we're looking for. I mean, I think the other ones are clear, right? The use of force claims. I'm going to check on the premium part, the slides, the loss run, and then can you help me, Mike? Say one more. I'm sorry, Commissioner Scholl.
Well, I wanted to kind of put a time period to it too. So either 5 or 10 years. So that we can look and see what I'd like to understand the trend, or if there's a trend. So, in the loss runs, yeah, and in the premium payments or annual premiums. So, I mean, if they're going up or they're staying, I think it's an indication. And I think to the extent, I want to be clear that in the information that can be made available, at a minimum, I'd like to see the nature of the payout, the amount, and the date.
Okay.
If that's any clear, I hope. But.
One other thing, Madam Chair, sorry. Can we also get Loveland's loss experience rating, our current rating?
Yes. So the loss experience rating also, please. Okay, so we have like 10 minutes left. I would like to thank Mr. Light for coming.
We need to vote on that.
Oh, sorry, motion. So can I get that motion approved or seconded?
A second.
Okay, so I don't want to repeat all of those things. That entire list of things we have requested and will get what Mr. Adams can provide.
10 would be preferable, but I'd accept.
That work? Yes.
I'm sorry, I'll make this really quick. And if it's possible to have any information, because I agree, seeing that trend is going to be very important. It would also be great if there is data available, maybe from the insurance carrier, as to comparable size and configured cities during that same period of time. So if our trend is going up at a 15% rate, is that better or worse than other like situated cities? Does that make sense?
It does, and while I don't disagree with you kind of in principle or in theory, I think I would just like to get the city's data first and then be able to take a look at it and then see if it is worth comparing to other communities to see where the more complicated I think we make this, the harder. But I do see at some point, Commissioner Stoddard, that where that information we could request that, and that's my opinion. So.
And I have no problem with this information being provided first and then seeing if the other information would be useful.
Okay, so let's move to, so the motion as it was standing, to get all of the information relevant to Loveland first. Can I get, we had a second, so can we get a vote, please? All in favor? Passes. Okay, and then, Ron, would you like to make a motion for next, or just table it for now? Okay, so we have just a few minutes left. Mr. Light, we appreciate you coming, thank you. we have on the next item on our agenda is to talk about the interviews that we're planning to have. I move that we, oh yeah, Jordan, would you like
Yes.
to type in on this one?
Yeah, so since we are running so low on time and I don't think that we'll be able to get through everything, what I plan to do is I will get with Jeffrey and we will send an email out detailing what it is that we would like from you guys to send to us, what questions and topics, and obviously there will be things that I'm sure have to, I wouldn't necessarily say be approved, but things that we may not be able to ask, but we'll be able to shuffle through all of those in our liaison meeting, me and Jeffrey, and we'll be able to have some set in stone questions and kind of a better idea of what it is that we're trying to gain out of this interview with Chief Ticer. But yeah, again, I just don't think that we'll have enough time as it stands right now to get through all of that. So we'll type up an email for the commission to read and give you guys another one of those assignments.
We do have some information that was provided by Commissioner Black for all of us. So we'll hand that out now, and then it'll go out in an email, and then we can all review it. And then Commissioner Black, can you speak on it next time?
Yeah, that'd be great. I'm still wondering if city manager approved that request to extend that invitation to Chief Ticer, and if
That is-
it has, if we've heard.
For next item, so perfect. Would you like to go ahead and speak on all of our requests? Because that was the next item.
So would you like me to respond to
Yes, please.
Commissioner Black's first? Okay, so yes, I have spoken to Chief Ticer, and I'm doing it in two parts. Looking at our meeting from last time, you asked for some information back for 3 years on a number of data points, including crime history, stats, disciplinary policies and procedures, history of use of force. So that's you've already asked for some of that. And so that part we're working on right now. And then the other thing is you made a motion at the last meeting that requested that I extend an invitation to Chief Ticer to speak on policies, procedures, how the police department addresses incidents unrelated to the Garner case, and then also to reserve the right for future discussion, obviously, after things have changed here. So that's what I'm working on right now for January 3rd. And I have a meeting with Chief Ticer later this week to go over how far along he is and what's going on. We're going to try and get you'd ask for the data first, so we're going to do that. And then that's what I'm bringing him here to talk about, is policies and procedures. So, and blue team was the other part of that too, because you'd asked about the blue team. I think that's going to take some time. So, but I don't know if that's what is motioned and in the minutes from previous meetings. That's what I'm working with him now to get prepared for his meeting with you on January the 3rd.
This is Commissioner Schneider. I would like to also propose the idea that Manager Adams is someone that we can interview and ask questions to about some of these processes from the city level. And that's really coming from resident input. So I want to put that forward. I don't know if we can make that motion to extend that invitation for a conversation to you, Mr. Adams, as well.
I will second that motion.
A motion to request that we also speak with City Manager Adams in the same manner about policies and things. All in favor? Passes. So
I have no idea what you want me to do with that. So maybe policies and procedures. I have thousands of procedures and policies in our city. So I need more help to kind of, what are you looking for? So I make sure I'm ready to talk about that.
We'll be able to get the information to you closer to time. As it stands right now, I don't think that we have all of those questions off the top of our head.
Okay. Keep in mind, it's a holiday time period, and some of us are actually on vacation during this time period. So
I understand. We're not necessarily saying that you have to come in on January the 3rd to go through all of this, but we're just saying that we're extending this to you.
So can we clarify if Chief Ticer will be coming on the 3rd?
yes, you will. Yeah, that's what we're planning right now. Yeah,
All right.
that's what you asked for.
So is there an expectation that we are going to provide, required to or asked to provide questions to the facilitator and the chair prior to that meeting for Chief Tyser? Is that what we've been, is that the implication?
Yes, since, we've got 4 minutes left, there's no way that we can figure that out right now. So yes.
So let's request that everyone send in their questions to the CTC, and then Jordan and Jeffrey can pare them down. Does that work?
Yes.
Yeah, I just want to reserve the right to, that we can ask additional questions that aren't otherwise like approved or vetted.
Right. We just want a better understanding of what direction we're trying to take this conversation is really what's going on.
Just a quick question. This is Commissioner Thompson. How many questions are we each going to submit?
Submit as many as you want, Merlin.
Oh my gosh.
Can we figure out a way to share our emails with each other so that they don't go into sort of a black box and then we don't know what each other have asked?
So,
I don't know.
The attorney is shaking his head no.
I can speak to that. What we can do that will not break the rules is everybody sending your questions to Jeffrey and I. We can make a Google Doc where, we can put your name, the questions that you have asked. If there are any repeat questions, we can cross them out, and then we'll forward it back to all of you guys in a group email that you guys cannot reply to.
Then I would like to request also to cover all the bases that we reserve 15 minutes with Chief Tyser to cover remaining questions that might arise during the interview.
Is that a motion? If it's a motion, I'll second it because I know we're short on time.
Before we, again, I don't want to complicate things, but if we have the ability to kind of directly ask questions of the chief, I would think it would be in our best interest to reserve the entire meeting to allow us to ask questions. Because once we put 15 minutes or put bookends around it, then we limit ourselves.
No, that's fair. I was just more in we have set questions that I think we'll all have, and then we're going to have more questions. So just to make sure that those get covered as well.
Sure. And I'm completely for that. I understand the intent and I don't disagree with it. I just think that within the framework of kind of what we're trying to accomplish, that we allow ourselves as much time. I mean, really it's the heart of what we're doing. So I would just say that we do reserve as much time.
Okay. So that'll just go on the agenda. We don't have to motion for it. Quick question, City Manager, how much time have we reserved for Chief Tyser to be here?
How much time have I reserved for?
Have you requested from him?
Oh, the whole meeting.
The whole meeting? Okay, cool.
Just on how we roll, I think we need to have as much time as we can with the chief, so.
Awesome. So next time we'll have the meeting with Chief Tyser. We're going to send all our questions into Jeffrey and Jordan. And then I move that we go ahead and adjourn.
Second.
All right. Good night, everybody.
Thank you.
So, Chief, but I think the chief coming in and giving
Every success is every success.
I think for him to start questioning the policy we have still these unresolved issues will not be good, especially if it's inconsistent with the settlement. So that one, I'm not sure.
So I've been sticking to policies and procedures, and they specifically ask us to describe the routine process. But there would be a set point PowerPoint. Oh, that we'll use that one to scan for everybody else. And then say, thank you very much, appreciate it. Thanks for coming. Bye.